Hello again, welcome to another Help with Law Problem Questions video. You may have seen others on this channel. Today we're in the topic area of criminal law and the crime is theft. And it might be worth you pausing the video possibly if you haven't already at this point and have a look at the problem question that we've been given, the scenario. It's a 20-mark A-level problem question, but whether you're doing a problem question at degree level or GCSE or other A-level syllabuses, the technique we're going to see is going to be the same, whether the question is more or less complicated. Okay, now you've read the scenario, and one mistake that can be made is that the student then goes straight into the answer and reads the scenario and says to themselves, yes, I can deal with that, I can see what's going on, and I've learnt enough law. And the danger there is if you don't read the actual question bit and you just look at the scenario, there is a risk that you will either do too much or too little as to what the examiner is wanting. So when you read the question, it's quite helpful. It gives you just a little bit more help. It's indicating who the defendant is, and it's Adrian because it's asking about his criminal liability. And it's telling you who the victim is. And on this occasion, there's just one victim, and it's Derek because it's his watch. Sometimes there are more than one defendant or more than one victim. Sometimes you see a crime against someone that they don't want you to deal with. So the question is always very helpful so that you concentrate on the stuff that's going to earn you marks. And again, helpfully, they tell you what the crime is in this question. They don't have to, or they don't always do that. They might let you decide, and that's a bit trickier because if you make the wrong decision about what crime it is, and typically a student might say theft when it's robbery, or robbery when it's theft, and burglary as well is another area where there's sometimes confusion. So be careful about deciding on the appropriate crime if they don't tell you. But of course, if they do tell you, then obviously it's that crime and nothing else. And the other issue here is by reading the question, we can see that although this guy's drunk a whole bottle of wine and is obviously very drunk, you might think about including the defence of intoxication if you know it and wanting to demonstrate your knowledge, but you'd get no marks on this occasion if you did do that because the question is actually saying you do not need to discuss any potential defences. So again, watch out for that, especially in criminal law questions where sometimes you can actually see more than they want you to deal with. Right, okay, now on now with technique, and there's generally two ways you can approach a problem question like this. The first is what I call the 50-50 approach. Don't be too swayed by the actual figures there, but what I mean is an answer in sort of two parts or two halves. As you know, probably you have to do the AO1 content for a law problem question. And on this occasion, this is OCR syllabus, the 20 marks comes from 8 marks worth of AO1 content where you're just explaining the relevant law. And you're going to get 12 marks for applying that law to the scenario, and that's the AO2, and that's the problem solving bit. And you get more marks for that, even if it isn't any more writing. It might actually sometimes be a bit less in writing, but it's trickier to do, so you get a bit more marks because you've got to take the law that you've learned and memorized and problem solve, off the cuff in an exam type situation. So that's one way of doing it, and the 50-50 approach would involve you doing an essay on theft within the remit of the question as closely as possible related to the question, but purely an essay. You just need to explain the law of theft. And then you would follow that up once you've done that in full with a big block of AO2 and then apply the law that you've mentioned to show how it relates to the scenario that you've been given. So technically it's a problem question answer of two halves. The alternative is, and it's all optional this, it just depends on the student's preference. The alternative is what I call the bit-by-bit approach. And here what you would actually do is you would deal with the law one bit at a time. And this works particularly well with crime. It works well with tort law because they're all very structured. It's like a series of hurdles that you've got to get over one at a time. It's very sequential. So the bit-by-bit approach works particularly well with criminal law and tort because if you think about the way you've learnt these crimes and torts, they're all very sort of, the first thing you need is this, and then you need this, and then you need this. And think about how you've been taught them. They've probably been taught to you in a sort of series of sequential things that need to be shown. And the bit by bit approach would involve you saying the first bit first, and then when you've said that first bit, you would pause, and then you would apply the scenario to that bit. And students find this very easy to use because you don't get sort of lost by, which you might with the 50-50 approach, you might get sort of lost in what you said earlier when you come to relate to it. So using this approach, if you say a bit of law at a time, and then while it's fresh in your mind, apply the scenario to it, you can then move on and say what the next bit is. And when you've finished doing that little bit of an essay, you then apply the law to that bit, and you just keep going. And that's why I call it the bit by bit approach. You're just quoting each bit of law in sequence and then showing how it applies to the scenario. So because I think it works particularly well for crime and tort. Contract law, by the way, I think is often better done by using the 50-50 approach, because for several reasons, but contract law isn't quite as sequential as some of the other areas of law, and you might just want to reel off pretty much all you know on that topic area and then follow it up by applying it to the scenario. There is a contract law video or two on this channel. Quite a recent one is one on consideration. You might want to have a look at if you're interested in that approach. Anyways, bit by bit approach for this one, for criminal law. So you may have noticed I tend to colour code these just to make it easy to understand what you're seeing. And the AO1 will be in yellow, so that's the essay bit, the explaining the law bit. And the AO2 will be in green. So there's our scenario, here's our question. And of course, the first thing you want to do is reel off a bit of AO1. You must start with some AO1. You need to be able to summarize the topic area. In criminal law, that often comes from quoting the relevant section of the Act, which contains pretty much all you need to start with. In tort law, that might, again, if it's a statutory tort like occupiers liability, you might be quoting section 2, 1 and 2.2. If it's common law, you might be quoting the relevant leading case that defines this area of law. Now, of course, with theft, you're going to be quoting the Theft Act 1968, section 1, because it is an excellent sentence and it gives you everything that you need to explain. It involves dishonest appropriation of property belonging to another with the intention of permanently depriving the other of it. An excellent sentence, as you've probably been taught, because it's all in there. You can then take that section, your opening piece of AO1, and break it down into what we need for the actus reus first. Always do actus reus first. There's 3 actus reus elements in theft, and that's appropriation. Defendant needs to appropriate the property that belongs to another. So there's your opening little paragraph of AO1. And then, of course, you probably guessed it, the first thing you need to do is take the first of those, and I would always do them in order. And the first of those is that we need the defendant to appropriate the thing that he is alleged to have stolen. And what you're doing here is you're just doing a nice little tidy paragraph on what this involves, and it might be a bit wider than the scenario itself. You need to get some AO1 down. Keep it as relevant as possible to the scenario if it's a large area, because you don't want to write too much that may or may not be particularly relevant to the AO2. But here, might be a little bit long. There's a reasonable paragraph here with some case law on what they mean by appropriation. That's pure AO1. And then when you've written that and got some credit for that, you go, right, okay, I need to apply this to the scenario to see whether this guy has appropriated. And often with appropriation, it is quite a simple thing to be positive about. And we've just got a little sentence here that talks about Adrian assuming the rights of the owner. Nice little quote from the case of Morris. because he takes it home, he has it in his possession, and he takes it home. There's not a problem there with appropriation. So you just need to confirm that to show that you've recognised that the law applies to this particular question. And then you move on and you do the next bit, and the next bit it can be a bit tricky, but it's one of these areas that is generally pretty straightforward. It's what they mean by property in theft. It's pretty much everything. It's physical property, it's intangible property, it's money, it's shares, it's debts, it's copyrights, and all that. And you can briefly say that in most theft problem questions, what they steal is physical or intangible property, and there's no problem. It's not anything weird like plants and flowers and wild animals and all that, which you may have seen some case law on. In which case I would keep it really simple and just say, yes, of course, there is property in this case, and it's X, it's whatever you've got in the scenario. And on this occasion, it's Derek's watch. I wouldn't really do any more than that on this occasion. Bear in mind that theft problem questions are, unless they're at the highest level, rarely going to involve problems with all 5 elements of the actus reus and mens rea. A couple of them at least are probably going to be really straightforward, so don't waste time talking about the ones that are obvious that the examiner really doesn't need you to spend much time on, because they've made it really simple. And it's often property, it's often appropriation as well, but property is often one of the simple ones to deal with. So I would keep it simple. And then, of course, by now we're already into the third and final element of the actus reus. And it's nice to mention the section of the Act, by the way, for each of these. We're already on section 5. And even the way the Act is sectioned and the sections of the Act work, it pretty much follows the definition that they give us in section 1. Yes, okay, the sentence in section 1 starts with dishonesty, which is a mens rea, and that's a bit of a shame. Could have reworded it better, perhaps. But appropriation, section 3. Property, section 4. Belonging to another, section 5. It runs sequentially from then on. So again, what do they mean by belonging to another? You go to section 5. You do a little quote from your studies. Section 5.3 and 5.4 are often particularly useful. They're quite common to see in problem questions. And as you can see here, section 5.3 is worth learning. It's where somebody gives property to be dealt with in a particular way. So it looks like a gift, and the defendant could argue that they've been gifted something, but it's only been given them to deal with in a particular way. I'm quoting that in the AO1 because it's useful for the AO2, as is section 5.4, where we get property by mistake. And you often see this with a sort of bank transfer or something like that, where somebody's perhaps overpaid wages and they keep it and say, well, it's mine now because it's in my bank account. Section 4 would deal with that and say, well, I'm sorry, but it wasn't meant to be put into your bank account, so it's theft if you don't return it. You don't always need to quote section 5.3 and 4 in the AO1, by the way. It just depends on whether it's going to help you and be a bit of a setup for the AO2. So I chose that particular paragraph for the AO1 on this occasion. It seems suitable. And then we need to deal with it. And the application on this occasion is, well, yes, it belongs to Derek, so pretty straightforward that it belongs to another. But then you've got these section 5.3 and 4 issues where it could be argued that Adrian has been given the watch when he says look after it, but of course there'd be an obligation there to deal with it in a particular way, and on this occasion is to give it him back when he's finished playing football, because that's why he's giving it him short term. And of course he does give it him by mistake because he thinks he's one of the team supporters and that he can be trusted and he's going to hang around long enough till the end of the match. So we've got a section 5.4 issue as well, which then is good AO2 because you can pick up on that, and it basically says, well, perhaps the defendant will argue these points, but our conclusion is, notice these mini conclusions. There was one for the on the issue of the other 2 issues we've dealt with. These mini conclusions that I've done in bold, we get the fact that yes, he appeared to have appropriated it. Yes, it certainly is property. Sometimes you can be more positive than on other occasions. Use words like is if you're really confident and it's not an issue, or maybe, or it appears, or words like surely and things like that to just indicate your thoughts on the conclusion. Here, my conclusion is it appears that Adrian has the actus reus of theft, because we didn't really hit any severe problems that raised too much doubt, did we? So there's our actus reus, and of course we've done it bit by bit. We've introduced each of the three elements in turn, quoting relevant law, explaining how that law applies, and then relating it as accurately as possible to the things going on in the scenario that the examiner has half hidden in there to see whether you can spot and deal with. Okay, so it then allows us to move on and go, okay, well, what's left is the mens rea, isn't it? We do the mens rea next. So you think about section 1 again, and you say, oh yes, it began with dishonesty under section 2, and the other mens rea element was this intention to permanently deprive under section 6. So back to the bit by bit approach, we can then explain what section 2 tells us about dishonesty, or what the law tells us about dishonesty for our AO1, and section 2, 1A, 1B and 1C are quite useful to quote in the AO1. Sometimes they're particularly relevant and therefore it would be good to quote in the AO1. If you're worried about time and don't want to write too much in the AO1, it could be skipped, but I've used it on this occasion because it might be useful for some AO2 commentary, because under section 2.1a, the law says, the Act says, a person will not be dishonest where he firstly believes he has a legal right to the property. And that's dealt with in my AO2 because perhaps he was very drunk. Perhaps he thought he was being given a gift and therefore thinks he's got a legal right to this property. It's possible, it's worth a mention. Also, under section 2.1c, it's not considered dishonest if the defendant believes the property owner cannot be reasonably traced, and that can apply to some lost property where the defendant genuinely thinks there's no chance of finding who this property belongs to and therefore keeps it. That might not, the Act would say that might not be dishonest. And we can apply that here because it's possible he was so drunk. We're not giving him a defence of intoxication here. We're just saying he might have been so drunk he can't remember where this watch came from and therefore has no chance of reasonably tracing the owner. So there's a couple of things we could say about sections 2.1a and 2.1c there. Section 2.1b believes he has the consent of the owner. Again, I mean, pretty unlikely, but his state of mind at the time might help him a little. But this intoxication thing, again, without getting into the defence of intoxication, we're not doing that. We're just talking about what he knows, because that's important to the defence of, to the mens rea element of dishonesty. It's important to know what the defendant knows, because of course we've got the test for dishonesty. To be honest, this two-strand test, I'm looking back at it now, really what should be in the AO1 at some point, I'm probably relying on the Act a bit too much, but at some point you ought to, in the AO1, explain what the test for dishonesty is. I refer to this two-strand test or two-stage test, and there's an inference in the AO2 as to what it is, but my advice here, looking back at what I've just done, would be to make it a bit clearer in the AO1. Explain this, what they call the Ivy test, Ivy versus Genting Casinos, as approved in criminal law by the Barton and Booth case. You've probably come across those in your studies. That's worth a bit of AO1 to explain how it works, this two-stage test. What did the defendant know about the situation that he's now accused of theft of? What did he know? And on this occasion, of course, we're not sure what he knew because he was quite drunk. But that's the first part of the test. And then the second part of the test is to allow the jury to decide whether this person was dishonest, is whether they're a reasonable person with the knowledge that the defendant subjectively had is acting in a dishonest way by doing what they did. So there's a reference to it here, and I'm sort of saying, well, it's likely that a jury would consider his actions dishonest based on that test, based on what he knew. I'd like to have put a bit more AO1 in the build-up to that in reflection. So there's your discussion of dishonesty. And then, of course, it leaves this final bit, section 6, intent. Mens rea of theft is intent, and think of the legal definition of intent, to permanently deprive the owner of this property. So you've sometimes got an issue with things like borrowing, where it's very short term and they never intend to permanently deprive. You've got things like taking something with an intention of returning something similar but slightly different back in return, this the Lumel case. And the Lloyd case you might mention in your AO1. And then when we apply it, there's this question, well, does Adrian intend to permanently deprive Derek of this watch? And perhaps there wasn't initially, but when he, and of course by now he's sober, puts it in his drawer, knowing he's got some property, puts it in his drawer and forgets about it, there appears to be an intention to permanently deprive the owner of their property by not doing anything with it that might encourage its return. And the final point here is this intention. It's an intention to permanently deprive. It isn't necessarily to permanently deprive. You don't actually have to permanently deprive the owner of their property. You just need to intend to. And the reason, of course, there is, if that were not the case, pretty much every thief who gets caught and the owner gets their stuff back would not be a thief if he didn't actually permanently deprive it. It's that intention, showing intent to permanently deprive the owner of that property is the mens rea. Opportunity to possibly include the legal definition of intent at this point, time and space permitting. But I hope you've learned from this structure, and I hope that's helpful to you. This, as I say, this is a demonstration of the bit-by-bit approach, where we take each bit of the law. You probably learn it in sequence, so it often helps to reel it off in sequence in a problem question. And while you're at it, while it's fresh in your mind, show how it applies to the scenario. If that was helpful to you, I'm pleased. And if you'd like to check out any other videos on this channel, I hope they'll be helpful to you too. Thanks for listening.